Hey everyone, Derek Johnson with Tatango.com. Today we're doing a TCPA review with Joe Bowser from Innovista Law, home of the TCPA Defense Force. How you doing, Joe?
Doing well, Derek. How you doing?
Good, man. Good. Well, we got a doozy today. This one actually, it's interesting, and I'll have you explain why we're even talking about this one, but this one has to do with faxes, which I know my generation doesn't really use fax. So a fax is essentially you put like a paper into kind of like a printer thing, and then the paper appears on a different printer somewhere else. For those young people that are watching this,
that's the idea. And the paper is often very scroll-like.
Yes.
So it spits out, and then you can use it like a periscope. Or
Man, we're dating ourselves. So I know we're gonna have one YouTube comment being like, "What's a fax?" So I want to throw that right out there, get it out of the way. Okay.
In fairness, there are a substantial number of TCPA cases about faxes. It's actually huge in healthcare.
Okay. So it is still an issue. Okay. So people still use them. So, but once I tell you kind of the facts of the case, then you can explain to me why we are talking about the
facts of the fax case.
The facts of the facts. Okay. You can explain why this even matters for text message marketing. So, okay. So the case is City Select Auto Sales versus so that's a business versus David Randall Associates. That's another business. So the plaintiff, the City Select Auto Sales, that's the person that feels like they've been harmed, right? That's plaintiff.
That's right.
Okay.
Yep. They got the faxes they didn't want.
Okay. So they received unsolicited fax transmissions. So they received faxes advertising the services of the defendant, David Randall Associates. And at least from what I'm reading here, David Randall Associates, he's like a roofer. Is that correct?
That's right. That's what the case says.
Okay. So he's sending faxes out to people in his community. And it looks like we're talking about a lot of people in his community, like tens of thousands. I think one of the numbers here was like 12,000 people.
The judgment against his company was about $22 million. So he sent a fair number of faxes.
Okay. So there must be a lot of fax machines still out there because, it looks like he sent like, I think 3 different sets of faxes, and the last one was to 12,000 different fax machines. So this was not a one person faxing somebody else and saying, hey, you want to use my roofing service. This was on a mass scale. This person was sending faxes.
Well, I'm sure it was a closely held company. The owner of the company is what the case is really about, because he owned 90% of the company with his wife, the roofing company, and he had one staff person whose job was to help with marketing. And it looks like he asked her to try to develop a fax campaign to advertise their roofing services. She reached out to what's called a fax broadcaster, which is kind of like you, Derek, in the fax world, right? You're an SMS platform provider. They're a fax broadcaster. So they do the same thing, right?
Similar company, just different channel of communication.
Right. Next century, right?
Yeah.
So fast forward a couple decades, and it's really you. So they still exist, and this David Randall company engaged the fax broadcasting company to send several rounds of faxes. They sent a decent amount of them, as you said,
to people in the neighborhood, to people in the city, people that were around, I guess, enough, like a radius of his business that would want to use his business.
Exactly. Right.
Okay.
Faxes have different rules about consent.
Okay.
So there the consent rules are different. Let's just leave it at that. We don't really care about what they are for SMS broadcasters and brands using SMS. But yes, I'm sure a small roofing company would have used the smaller footprint of recipients.
In text messaging, though, you have to have a strict opt-in from the consumer. So just saying I want to text message all the people in my city about my new restaurant would be a gross violation of the TCPA. If you ever hear that from a software provider, text message marketing, run the other way. That is just complete. There's no argument on that side. You have to get an opt-in from the consumer, and it has to be initiated by the consumer. You can't text message. I've seen this before where they ask to text message the entire city asking if they would like to opt in. That's a gross violation as well, right? From a text messaging.
I could not recommend that.
Okay, good. I never recommend it either. And if your SMS provider recommends it, again, run the opposite direction. So
okay, get a second opinion.
Yep. Yeah, definitely. Second, third, something like that. Okay, so he sent out a lot of faxes, and I think in different waves. So he sent like one fax, to a lot of people, and then he sent another one. And it looks like a lot of people in that community, these faxes were unwanted. So he got a lot of people were upset. They called this company and said, hey, remove me from your fax list. And then I think one person got really upset, and he decided to go more of the legal way of kind of punishing, trying to punish this company for faxing his company. Is that correct?
That's right. They're not just for that company's faxes that they received, but he filed it as a class action. So he was representing not just his own business, but also anybody else who got an unwanted fax from that defendant, from the David Randall Roofing Company.
Okay, so he was like, I'm going to really stick it to this company. I'm going to not only include myself, I feel like I've been wronged as a business, because this was a business fax machine most likely. I'm going to go around to all the other businesses that receive this fax, and they're going to join me in this case.
In concept, you don't have to round them up like horses or anything. So you just file the case and say, I'm here both on individually and on behalf of all others, so-called similarly situated, which is to say people who also got that. There's a class opt-in process that happens.
So he doesn't even need to actually get the 4,000 businesses and get them joined before he goes. He can go to the courts and say, I am, doing this, but I know people, that also have this, and they're going to join me eventually or somewhere down the road.
Oh, they have no idea who is in the class. Oh, because they just assume that there is a class. Right? No idea.
Okay, so that would come in discovery. They would figure out all this info.
Right. You asked for, whoever you faxed, whoever you called, whoever you texted in that campaign going back 4 years. So that's what class discovery usually focuses on. What is the scope of the class? And then what are the issues that might defeat class certification, which is the process where the court, under the rules of civil procedure, says, okay, your case, named plaintiff, is sufficiently alike everybody else's that it makes no sense to force everybody else to file an individual claim against this defendant. So we're going to use the class vehicle to, not bog down the courts and duplicate the evidence case after case after case.
Yeah. Okay.
So typically the plaintiff has zero idea who their friends are in the class scenario.
And it might have been easier for him because if it's a small community, everybody's frustrated this business for spamming them. He goes, well, at least there's 3 people down there that got it. This is a malicious kind of act, essentially. Now, before we get too far into this is a text message marketing, YouTube channel. I know text message marketing. You're a TCPA attorney, so you know TCPA compliance. Why are we reviewing this case if he did not send any text messages?
Because this case is hugely important for who can be held liable for TCPA violations of any kind. Okay. Text, call, fax. That's it.
So the TCPA doesn't just apply to SMS or MMS. It applies to phone calls and faxes.
Well, the TCPA doesn't even mention text messages or SMS.
Oh, yes, I remember that. Yep.
Those words don't appear in the law because the law was passed in 1991, 2 years before the first commercial SMS.
Wow. Okay.
So the FCC and the courts have said Congress must have had in mind this technology that barely existed except as a prototype when they passed it in 1991. Yeah. So the courts have done Congress a solid and said, we're going to go ahead and read. When I read call in the law, I'm going to, basically expand that to include text messages.
Okay, so when there's cases that are TCPA cases that there's no text messaging involved whatsoever, but there's faxes or calls, the results of those cases can have an impact on future text messaging cases.
They absolutely can. Okay. And this one's a great example because the key issue in this case isn't whether the company is on the hook. It absolutely is.
Yeah.
They got like I said, they got a $22 million judgment against the company.
Oh, so it's been resolved already. It's like you were at fault, the company. It was $22 million. And that's a lot of money. Good reason not to spam people. So that's been resolved. So there's something else that is kind of another. That's obvious, and they shouldn't have done that, obviously. And that's why I think there was a judgment. But there's something else now being kind of talked about or trying to figure out with this case, right?
Right. So this was a closely held company by the owner of the roofing company. He owned 90% of it. So the roofing company probably had a truck, 2 trucks, some ladders, some shingles, maybe a warehouse. How close is that to your $22 million judgment?
Yeah, the business itself didn't have enough, assets or insurance to cover that $22 million. Now, a business like maybe Toys R Us is a bad example, but I don't know when we're watching this video, but they just went bankrupt. But a company like Target or Kohl's or a big, Chipotle or McDonald's, they have a lot of business assets. They have a lot of company, assets and insurance. But this example, there was a $22 million judgment against the business. The problem is the business really doesn't have that much money. Maybe all the money is with the owner, or there's a little more money than maybe with the business.
Right. So, but I wouldn't put your Targets and your Home Depots and your Chipotles to the side, because this case raises an important question of when even the corporate officers of those big companies can be held personally liable for the acts of their company.
Okay, right? So this isn't just, hey, you don't have the money, go to the next one, the owner of the business. This is corporate officers in any company can be held liable for TCPA violations.
Right. So for about 2 decades, courts had just assumed, without thinking about it, oddly, that you could name corporate officers for TCPA violations if they were actively involved in the marketing campaigns. Okay. So if your CMO, your chief marketing officer, is developing the campaigns and deciding who gets what when, it was assumed without thinking a lot about it that you could name them in the case. You didn't necessarily see that in every case because, the plaintiffs and the plaintiffs' attorneys would assume the company would be able to satisfy the judgment, and the company was probably going to defend and indemnify, or the insurer would defend and indemnify the officer. But it's not obvious that every company has rock solid TCPA coverage for either the company or the directors and officers and other principal actors within the company. So it's not a foregone conclusion that the officers are able to get off scot-free. So what the courts had been assuming that was the case was at common law, which is, obviously America has a common law system, which is to say the courts make a fair amount of the law, right? In so-called torts and contract law, Congress and state legislatures don't really get involved in writing statutes about how those laws are going to work. Okay. The TCPA is a statute, that's so-called civil law, and different countries like, Louisiana, or states like Louisiana and France, they'll have a civil law system where essentially all of the laws are on the books, as it were. Okay. But in America, for something like torts, and the TCPA is thought to be a tort because it's an invasion of privacy claim. So courts think about the TCPA as a tort claim. And in tort claims, if you, a corporate officer, are actively involved in the commission of a tort, you can be personally liable for those torts along with your company. So this is back to England from the 1600s, right? This stuff is hundreds of years old. And courts had just assumed, without thinking about it, that, let's assume that Congress was legislating against that backdrop, and therefore we're going to continue to maintain that notion of personal liability for corporate officers when you commit a tort. Okay. So if a corporate officer of UPS is driving the truck and he hits somebody, you can hold that corporate officer liable along with UPS because he was involved actively, because he was driving in the commission of that tort. So too, like if you're sending the messages or choosing when to send the messages and who gets them, some of the trial courts had just assumed, yeah, let's keep the officers in the case because of this common law reflex that we have.
Okay.
But the Third Circuit went out of its way in this case to say, hold on, why is everybody assuming that the corporate officer is even rightly in this case? He had to go to trial, defend himself, pay to defend himself individually, and it's not obvious to us at all why that's the case. And they go back to a 20-year-old Supreme Court case called Discover, where the Supreme Court basically said, unless Congress explicitly says a corporate officer can and should be held liable under that personal liability theory, we're assuming Congress didn't mean to do that because they've explicitly said when they want personal liability exposure so many times. So given Congress's ability to say, hey, I do want to maintain corporate liability in this statute, when Congress doesn't say it, and they didn't say it in the TCPA, they've said to the courts, don't assume I want personal liability. I, Congress, want to maintain personal liability for corporate officers. So here, the Third Circuit went out of its way to say, I want extra briefing on this issue. And the two judges who issued the majority opinion said, I don't think corporate officers have personal exposure for TCPA violations at all.
Okay, so this was maybe I'll break this up. There was the original case, which was, you spam me, you owe me some money. That was the original case. Then,
but they sued both the company and the owner because they probably knew the company didn't have a lot of money.
Because the money usually in those small businesses goes to the owner.
So the owner probably had a decent house. He's got a boat. He's got whatever assets he has. And they probably knew the roofing company had the truck and the ladder, and that was never going to get them anything.
Yep. So that was the original case. And essentially, this guy won, and he, won.
No, he didn't. He won at trial.
At trial. So they said $22 million. Then they had to go take it to somewhere else to get like a ruling on whether the guy that owns the business was liable for that.
So what happened was the plaintiff won on summary judgment against the roofing company.
Okay.
So it was a clear violation.
Okay.
So they entered judgment against the roofing company for $22 million before trial.
Oh, so it was like a slam dunk case.
That was a slam dunk case against the company. What they went to trial on was whether the owner of the company could be held personally liable.
Okay,
and the plaintiff
included
lost.
In that. Okay,
exactly.
And the plaintiff is which one? The plaintiff is
the car company.
Okay, so the car company, they went to court and they said, the car company said, hey, this roofing guy, the guy that owns the roofing company, should also be included, should also be liable for this $22 million because the small roofing company doesn't have any money or has very little money. And then at that trial, what happened?
So what happened was they were fighting over the jury instructions about what the applicable law should be. And the Third Circuit said, given the current state of the law, the trial judge got it right. And then the jury found ultimately that the owner wasn't sufficiently involved in the campaign. But this was very fact specific because it ended up turning on, did he actively oversee what his staff person was doing with the fax broadcaster? Turns out he didn't really look at the faxes. He kind of counted on her to run the day-to-day marketing stuff. Yep. And so he got a little lucky. Like if the facts were a little different, you could see the jury having come out differently and all of his assets would have been on the line under the assumed state of the law. So the jury said, you know what, I'm not holding you personally liable because you weren't actively involved in the marketing campaign. You were doing the roofing, you were running the show, but you weren't micromanaging what she was doing. What did the fax say? Who did it go to? Which vendor did you pick? Okay. And so the jury decided, I'm not holding this guy to that.
So for text message marketers, let's switch it to text messaging. For somebody, I guess, that has a large enough company that maybe the owner or the principal or board member, they have marketing people below them, and the owner most likely, he knows they have a text messaging campaign, but he's not directing them. He's letting all the marketing people handle that. In this case, it seems like that the owner is not held personally liable for the violations of the TCPA that the employees, do.
Committed.
Yeah, committed. Right. The business is obviously, held liable.
Sure.
But what changed is if the owner was involved in the text messaging campaign. So if he was kind of the person, spearheading the promotion, he was coming up with maybe it's a smaller business and, he doesn't have so many marketing people below him.
Right.
Did something change here with this case that now he, like back in the day, he wouldn't be usually held liable, but now he could be? Or
the opposite. Okay. So the trial court took the law kind of as it's been assumed to be, which is there is potential exposure for corporate officers who are actively involved. So in the example you just gave, the president or the high levels, the C-level person at the company, if they're actively managing the SMS campaign, in other courts, apart from the Third Circuit, there's real exposure, even today, for them on an individual basis.
Okay.
So their assets, their house, their car, their, whatever's in the bank, et cetera. Yep. John Smith, Jenny Smith, the CEO, there's exposure there on a personal level for your actively managed campaigns.
Okay.
What the Third Circuit was saying was, hold on, why are we assuming this to be the case? I see nothing in the TCPA, the law that Congress actually passed, that shows that they want corporate officer liability, because the whole point we create companies is to, well, not the whole point, but a major point is to create that layer of insulation between our personal assets and the corporate assets. Right. So as long as you're not playing games with the corporate form and you're respecting the corporate form, and there was no indication in this roofing case or in most cases that you don't respect the corporate form, right? Like the faxes or the messages are going out advertising the company services, not your individual services, right? Like all of the money and benefits redound to the benefit of the company. You are respecting the corporate form, and federal courts respect that. So the Third Circuit said, why are we assuming that we're just going to blithely ignore the corporate form and pretend like none of this ever happened, when Congress never said, I want to carry forward the common law and hold these guys personally liable? Okay. Because Congress knows how to do it in other laws and did it in other laws and didn't do it in the TCPA, I'm going to assume, because of the Supreme Court precedent, that Congress knew how to do it and explicitly chose not to include personal liability in the TCPA. But because it wasn't briefed and argued at the trial court, the Third Circuit, because they could easily affirm on the facts, they said, look, even under the old law, he's not liable, so I'm not going to make this the end-all and be-all. But everybody else, be on notice that if you try to hold a corporate officer liable and they maintained and respected the corporate forms, don't expect a favorable audience from me if you try to sue them.
Okay. And
like, you need a rogue CEO.
Yeah. And you said this was part of like the Third Circuit?
Yeah. So Third Circuit covers Pennsylvania, New Jersey, Delaware, and the ever popular Virgin Islands.
Okay, so this is interesting because a lot of people think TCPA is just a blanket, cover across the United States and everything is the same. You're saying that in those certain states, things are a little different, or they're interpreting it a little different or reacting to certain cases different ways.
Yeah, so we've got three levels of the federal courts, right? We've got trial courts, the federal district courts. We've got circuit courts, which are the appeals courts, including the Third Circuit. And then we've got the U.S. Supreme Court. If the Supreme Court issues a ruling about the TCPA, that is the law of the land. Okay. And that's final until the Supreme Court changes its mind or Congress reverses the Supreme Court, assuming we're not dealing with constitutional issues. The circuit courts of appeal, like the Third Circuit, they're very persuasive to courts even outside their district. It's not binding, but it's very persuasive. So if you had a case in Tennessee, Texas, California, they probably would not ignore that, and they give it good weight.
Okay. But they're aware of it. They're looking at the cases. So it definitely helps across the United States, but it's not binding like in those states.
Right. Okay. Yeah. So the Third Circuit opinion is only binding on the trial courts below it.
Okay.
But it's still persuasive because it's the first circuit court case to deal with this issue head on.
Okay. Yeah, because a lot of these judges in courts, they don't want to have to make up their own opinions. They want other people look at the other facts and the other cases and go, well, it happened over there, so that's what we're going to base it on. That's what we're going to go forward with. It right. Seems like they're not always coming up with their own thoughts. It's essentially always what has happened in the past.
Well, you can certainly get splits, and there are splits in the circuits even on TCPA issues. So another circuit court might not agree with their analysis.
Oh, so and again, two, like the one will say, yes, corporate officers are held liable. One will say, no, definitely not. So it really also depends where the business is located, what your terms and conditions, where the arbitration happens, or where the I guess court case happens. So there's a lot of factors, I guess, here. And
that's why when we do these videos, I hope that they're very helpful to the audience. But you've got to give a very subtle, nuanced analysis about where you are, what your risk tolerance is, because there's very few Supreme Court cases that you can take to the bank, and everything else is it's ever changing, right? I mean, this case came out a couple weeks ago. We've talked about cases before that are fresh and topical and changing the law on an ongoing basis. There's 4,000 to 5,000 TCPA cases filed every year, and so a lot of these cases percolate up to the appellate level, and the TCPA case law and regime changes on a fairly regular basis. Wow. So you want to make sure that you're paying attention to the nuances and the regional variations across the issues that matter to you.
Yeah, and that's why we at Tatango always recommend getting your TCPA advice from a TCPA attorney, and usually outside counsel. I've seen some SMS providers where they have inside counsel that tries to kind of help clients, and I'm like, that's always kind of risky, because who is the attorney actually representing? And it's always the business or the SMS provider. Always get a third-party opinion. And usually I always recommend a TCPA attorney. This is not something where this local roofer should have gone to like his local attorney, his business attorney. TCPA is so complex that you guys at Innovista Law only focus on TCPA, and that keeps you busy.
Right. Yeah, so, we decided to, really hone in on the TCPA work, and we're only defense side. We only represent the brands, the platform providers, and anybody on the other side of the V of a TCPA case. And we obviously do counseling and compliance work to make sure that you stay out of court. A well-constructed campaign keeps your consumers happy, engaged, and they think that you're sensitive, and they rightly know that you're sensitive to their needs, respect their privacy, and, that's a classic case of ounce of prevention. So for us, the happiest clients are the ones who come in for the compliance and the audit work, because they get it right on the front end, right?
Yeah.
And you don't have to worry. Hopefully, don't have to worry about the plaintiff's attorneys knocking on your door.
Yeah. And I think in a lot of TCPA kind of stuff for text message marketing, it's not that daunting. Especially if you're playing kind of in the non-gray area. Some things, it still is kind of a gray area. But when you're doing like mass text messaging, doing the double opt-in, getting them to consent to the terms and conditions, making the text message, perfectly crafted so they reply yes to the perfect text message, right. All of those things are pretty standard. It's not.
We don't spend a lot of time on those. No.
Yeah, exactly. So, I don't want people to think that, TCPA compliance for like a mass text messaging campaign is something that is going to take years to get right. But it is something that they need to. You can't just do once. It is a constant kind of update and checking and seeing how people are responding to your messages and making sure that they know how to opt out. And there's just all these kind of nuances which. We as an SMS provider, we focus on building SMS software, just like we don't do faxes and phone calls and all these other things. You guys focus on just TCPA compliance. So I think there's something to be said there about like focus, especially for the TCPA.
And then we get to tell all of our friends that we can't help them with their speeding tickets and other run-ins with the law. It's good cover.
Yeah, nobody's calling you in the middle of the night, most likely. Hopefully not for a TCPA case. So
depends on their time zone.
Yeah, exactly. All in all, for this, it seems like for text message marketers, the law is now a little more friendly in one place or one, I guess, circuit for directors even if they're involved in the text messaging campaign. Right?
Right. This is our best first wedge to get directors and officers out of the case from the start.
Okay, so this is good news for that specific area, possibly, other areas. And then if other courts, rule the same way, then it's kind of like it's a seed essentially, and it could germinate to everything. And that's good news, obviously, to remove personal liability and really keep the liability to a business.
That's right. And, I get these calls regularly. I mean, I get folks who call in and say, I'm calling with two hats. I'm calling because I'm worried about my kids' college funds. Yep. But I also want to do this right and make sure, our company is doing things properly and that we respect our consumers' privacy, et cetera, and don't land in a plaintiff's lawyer's lap.
Yep. Okay. Perfect.
So, this is a very real world question that we get on a regular basis.
Yep. No, that makes sense. And it's a concern, I guess, especially if the director or something doesn't even know, what's going on, in terms of their text messaging campaign, right. That would definitely be a concern. And what are the fines for violating the TCPA? This isn't like $1 per, text message. It's $500 to $1,500 per text message. So these aren't like, Honda Civic type, forfeitures of assets. These are like, boats and houses and all of your savings. Like these are huge lawsuits. They're not small.
No, this gentleman lost his entire company because his admin sent a few months worth of faxes.
Yeah. Wow.
Right. I mean, that company is wiped out, right?
Yeah.
It's $22 million for a 3-month marketing campaign.
Yeah. Yeah, I'm pretty sure he didn't generate $22 million in revenue. I think he just most likely pissed off a lot of people in his community.
Right. That's a lot of shingles. Yeah.
Yeah, which is why also not even taking into account the TCPA and the law and stuff, just sending unwanted text messages does not look good for your brand. Even if nobody sues you, it just angers people. Right. A phone is such a private, a phone number is such a private, thing. Don't do it. Like, even if it were, luckily we have the TCPA because it puts some kind of restrictions against doing it. But when we hear a brand that wants to do it, wants to send unsolicited text messages, first you got to ask, like, why? What's the point of, you're going to anger more people than the revenue you generate. And then secondly, which is even more important, I think, is you will most likely be sued even. And we used to say, we used to hear this back in the day, is they would go, well, I'm a small business. No one would sue me. And I think...
Ask him.
Yeah, exactly. Because... Yeah. And I have heard that before from brands where they're like, well, I know that, the big boys always get sued, the Targets, the Kohl's, like they're always being sued because they have deep pockets. No consumer is going to sue me because I'm a small pizza place. And this is not just suing you. This is putting you out of business. Like these lawsuits are so big. So I think this is relevant to big companies with the corporate officers that want to protect themselves. I think this is moving in the right direction. But then also proving a point that really any business, even a roofing company with a couple trucks and a couple ladders, can be on the receiving end of a multi-million-dollar lawsuit.
That's right.
Wow. Okay. Anything else that text message marketers should know?
I think we got it.
Awesome. Okay. And you have a lot of resources on your website, resources and the blog. Where do they find that?
We've got a ton of free content on there that will help you, get up to speed. It's at tcpadefenseforce.com, tcpadefenseforce.com.
Awesome. You guys
Thanks so much for having us on, Derek.
Yeah, and you could do a ton of webinars. The blog is amazing. Like, it's always up to date. So anybody interested in this stuff, definitely stay kind of in touch with them, and then they can reach you, obviously, on that website. That's great. So again, this was a TCPA case review for City Select Auto Sales and David Randall Associates. Again, two businesses kind of duking it out here in a small city, which is always fun and interesting. Again, thanks, Joe, for joining us, and we'll see you guys soon.
Thanks, Derek. Thanks, everybody, for watching.